Mr. Ongwen was convicted on 4th February for war crimes and crimes against humanity, and he was sentenced to 25 years of imprisonment. On 28 February 2024, the trial chamber issued a decision which confirmed the conviction of Dominic Ongwen, and the defense subsequently appealed it. So yesterday we saw the presiding judge, Justice Bosa, reading a summary, and I want to emphasize it was a summary she read, and clearly she indicated it wasn't, or it's not the authoritative document. The decision itself, the full decision, is on the court's website, but the summary was provided for expediency, just to be able to touch on the main aspect of the decision. The judges looked into the various counts that were appealed. A total of 14 of them were appealed. And the first ground the judges looked at, very important, was whether the defense had found that the trial chamber had made a mistake, had erred by not providing the names of the potential victims. They wanted the names of the potential victims to be revealed to the defense. However, the judges, I'm finishing a meeting. I need to talk to you back. Sorry guys, I'm in the office and a little bit of. So the appeals chamber considered the grounds of appeals raised by the defense, and among many findings, the chamber concluded that the trial chamber decision on the reveal of the victims' identities to the defense was not justifiable. That the judges of the trial chamber did not make a mistake by deciding not to disclose the names of the victims to the defense. They considered that the dossier of the victims, the defense would still read it without having to review the names of the victims. The appeals chamber also found that there was no error in rejecting the defense's argument regarding an overlap, because the defense argued that there is a potential overlap among victims who may receive compensation before the Uganda National, and the same victims of the possibility of receiving reparation at the ICC, and they challenged this as an overlap that the victims will benefit 2 times. But the appeals chamber clarified that these are 2 different regimes. The regime under the Uganda National System, for which victims will receive compensation, is totally different from the regime at the ICC, and they dismissed that ground, and they did not find it was overlapping. The appeals chamber noted that the compensation discussed before the National Tribunal was different from the reparations awarded by the ICC, and it concluded that the defense has failed to explain how the actually traditional mechanism should be incorporated into the reparation system under the ICC's legal system. This was another ground of appeal, a third one, in which the defense was saying that given the traditional systems, the reparations should be conceived in such a way that the actually traditional system mechanism should be incorporated into the system, into the reparation system under the court legal text. The appeals chamber therefore rejected this particular ground for appeal, and all the arguments, noting that they were already been dealt with and rejected as an order appeal that was lodged by the defense when he was found guilty. In deciding the appeal, we already saw the judges. It was 5 judges who studied the document and read the merits and rejected all of the grounds of appeal for which Dominic Ongwen filed. We'll just go through them if you like. Briefly, the first appeal was alleged erroneous refusal to disclose the names of the victims. I already talked about that. The first ground, the defense presented that the trial chamber made an error by refusing to order the disclosure of the names of the potential beneficiaries of reparations, in which the appeals chamber argued that in deciding to redact those names, the chamber did not make a mistake, it did not err, and that it was for the safety and security of the victims. In the event that Joseph Cone and Dominic Ongwen returned back after serving his sentence, and therefore, for the safety of those victims, it will not be possible to reveal them, and that the trial chamber did not make a mistake in deciding not to have that disclosure regime done. The second ground of appeal was alleged error in the trial chamber's finding related to domestic proceedings, which I already mentioned. Under this ground, the defense has submitted that the chamber made a mistake or error in rejecting the defense's request to have the names of potential victims submitted to them so they can review them. And the judges are like, it will not be possible to do so because obviously it would jeopardize the security and safety of the victims in a situation that the Dominic Ongwen returns to the country after he serves his sentence. And then the third ground of appeal, that there's an alleged error, presuming that persons regarding in the IDP camps were not present at the time of the attacks. This was the argument of the defense. But then the appeals chamber observed that the defense may have confused a little bit the presumption of victimhood with the presumption of the harm that the victim suffered, and that the trial chamber did not make a mistake in considering the harm as well as the victimhood of the victims within the context of that camp, and that ground of appeal was also rejected. The chamber lumped ground 4, 11, and 12 of appeal, in which the defense alleged an error concerning the trial chamber's consideration of the actually traditional and cultural factors and mechanisms to be incorporated into the reparation regime. And all that is combined 4th, 11th ground. The defense alleges that there is an error in the decision of the chamber in considering the concept of extended family, which resulted in indirect victims with a large number of indirect victims, and that the issues of complementarity, so that the actually traditional mechanism will serve as complementarity, serve as complementarity. But the police chamber is saying, to the extent possible, the principle of complementarity does not apply in this argument. And contrary to their claim, the chamber did not equate this concept of shame, the spirit, to mental health of modern medicine, because there was also an argument that seemed to suggest that mental health is the same as shame. But the appeals chamber clarified that while shame might be spiritual, but that also can affect someone's mental health, and which was presented during the case of during the trial, and they dismissed this ground of appeal on the basis of that there are spiritual disturbances that had lasting impact on the consequences of the mental health of victims. The appeals chamber rejected all the 4 grounds which they grouped, the ground 4, 11, and 12. The 6th ground, they said the chamber made an error in prioritizing direct victims over non-participating victims. Under the sixth ground, the defense was submitted to the chamber that it had made a mistake in prioritizing participating victims. You recall that when the reparation decision was issued, the judges gave different categories of victims that are eligible for reparation. But in the same context, they gave 4 categories to be able to efficiently allocate the reparation that they have to be prioritized. And one of the prioritized groups is participating victims. And the defense has said that the priority that is placed on participating victim kind of is not representative because the non-participating victims are large. And the appeals chamber notes that the defense misrepresents the decision by focusing its argument only on victims' participation. However, there is merely a part of the prioritization. There are 4 categories, and one of them is just about the priority on participating victim. And the judges say, well, you did not even give us a context in what you're saying this because you misunderstand or you misunderstood totally what the trial chamber was saying, and therefore this ground of appeal was also rejected. The 7th ground of appeal, under this ground, the defense submitted that the trial chamber made an error in failing to require sample of medical documentation to prove the disability of certain victims. The appeals chamber, however, drew the attention of the defense that those 2 victims in the application that they made did not make mention of having received any medical assistance or sought professional medical help. Therefore, it was the assumption of the defense to think that these victims had presented medical forms, and on that basis, the request was rejected. The judges said it had no merit, and it was rejected. The 8th ground of appeal, the defense said there was an error concerning the scope of Mr. Ongwen's liability in relation to the time he was a commander. And in their filing, the defense were of the view that the trial chamber made a mistake or an error in estimating the number of victims of the thematic crime. The defense also argued that the trial chamber did not take into account the period when Dominic Ongwen was appointed as commander of the brigade, of the senior brigade on 4th March, and that the trial chamber's scope appeared to be bigger for thematic crimes. And the appeals chamber said yesterday they found it totally inappropriate that the defense was attempting to relitigate, because this was a matter that was already dealt with during the trial, and by the defense bringing it out of as appeal, the judges of the appeals chamber considered the defense was trying to restart a process that was already laid to rest during the trial process, and the defense in any case has failed to demonstrate the error concretely. Therefore, the appeals chamber dismissed this count. There was a 9th ground of appeal in which the defense alleged errors concerning the trial chamber use of numbers of divisors of 4 instead of 5. They alleged that the brigades were divided, the LRA brigades were divided into 4, and they said the prosecutor, the trial chamber mentioned 5. But in any case, the appeals chamber of the view that some of these brigades really acted, or some of the brigade, the control alters acted as brigade, and that the trial chamber did not make an error in this. And they also noted that during the trial, the defense never made mention of this concern, and it was too late at this time to decide on it, and they consider it does not have merit, and it was rejected. On the 14th appeal, they allege an erroneous assessment of moral harm. The defense said in their 14th appeal, they submitted to the judges that the trial chamber made an error when determining the moral harm that the victim suffered without requiring psychological evidence to examine the victims by a pathologist. The defense said this was required before the judges could have said victims suffered physical, psychological harm. The defense raises the issue for the first time. The judges also said this is the first time the defense is raising this issue. It did not raise these concerns throughout the proceedings with the trial chamber. As a result, the trial did not have the opportunity to consider it at that time, and at this stage, they cannot examine it. It is outside the scope of their mandates at the appeal, so it was rejected. The 14th ground of appeal, they alleged that the trial chamber made an error concerning the trial chamber's eligibility assessment of 4 victims. And the assertion is that they did not provide, or they did not meet the standard. The victims did not meet the balance of probability. I've been read through their application forms, and they refer to, in respect to the first and second victims, the appeal chamber noted that the defense misrepresents the trial chamber's relevant findings, and it fails to identify clearly any error, because if you say the trial chamber made an error, the appeal chamber was saying, show it to us concretely. But in the defense's appeal, it was not shown concretely where the trial made an error, the trial chamber made an error, and therefore rejected the appeals of the prosecution, of the defense, I beg your pardon. So for all the reasons that the judges summarized that yesterday, they dismissed or rejected the defense's appeal and confirms the impunged decision. And what does this mean? That the reparation order in its entirety stands, nothing missing, nothing omitted, and that it should be implemented. The anticipated number of victims, the amount, the liability of the money that the defense also challenged, that 750 is not in the Rome statute, and that they should not have given it to the victims. The judge said, well, the scope of reparation is broad, and that a judge or chamber has the liberty to award different forms of reparations depending on the crime for which a person was convicted. So all the grounds of appeals were rejected, and the chamber confirmed or upheld the decision of trial chamber 9. And they are either direct victims or indirect victims. And when the reparations could commence, you recall that when the decision was issued on the 28th February last year, the judges gave or delegated different mandates to various sections. One, the trust fund for victims, to raise the money, the liability. The money is more than 52,000 euro that the trust fund is to raise to pay reparation. Both direct victims and indirect victims, the symbolic order of the 750, this community-based collective reparations, and the rehabilitation that have to be conducted. So the money is not there, it has to be raised. Well, even before that, they gave them a mandate to prepare a draft implementation plan. They conducted extensive consultations with victims, different stakeholders at the local national authority to seek the views on what they intend to be contained in the draft implementation plan. This plan was submitted on 3rd September last year, and early this year, if I'm not mistaken, in February, sometime in February, the plan was approved. All of it, all the plan has been approved, which means it has to be, they have been given 4 months to put together immediate activities. But even before that, there is the Victims Participation and Reparations section, which was given the mandate to identify these 49,722 victims, to assess their eligibility, whether or not they fall within the scope of this reparations. So identify, assess the eligibility, and a lot of work has been going around behind the scenes in terms of preparing administratively to start this process. Our colleagues in the VPRS have identified the clerks. They have put together a strategy on how they intend this registration or this identification to take place in the communities. 2 weeks ago, they've conducted the trainings, they've consulted with the LC5s, the chairman, and the RDCs in all the districts in northern Uganda, including Teso, Mali, to inform them of this process that is going to roll out, so that if they see a clerk in their community, they will not be shocked or surprised why they are there. And these clerks have been given certificate of identification so that they are known in the communities. The process will roll out in the next 2 weeks, effectively or concretely, when the college registration or the identification of victims will commence in earnest. So we want to make sure that the correct victims, the legitimate, and victims who fall within the scope of these reparations receive them. So the administrability, eligibility criteria assessment is ongoing. It's a long process. The VPRS was given an initial 2 years starting last year, which 1 year is already gone into it. And we are hoping that they will ask for an extension, because it's a huge number of victims that have to be identified and lined up and assessed. Because registering does not automatically qualify the persons to receive reparation. They definitely have to be assessed to make sure they fall within the criteria of eligibility before they receive the reparation award.
Yes,
okay, remember the Dominic Ongwen was found guilty, and the reparations order was issued, closely linked to the crimes for which he was convicted, and for the benefit of victims or potential victims who would be the beneficiaries of that reparation. It is the right for the defense to appeal any decision as long as it is authorized by the chamber. When a decision is appealed or a motion is appealed, the possible outcomes could be a reversal, sometimes of the entire decision, a reversal of components of the decision. These were 14 grounds. They did not, in any case, encompass the entire reparation decision. Let's even say, for the sake of argument, some of those grounds were upheld by the judge, or the grounds were the judges would have said, yeah, there's an error here, an error in law, an error in fact. Therefore, we are going to send the matter back to the trial chamber to look into it, because we found an error. We ask you to revise it because you have made an error, it is outside of the law. Because those are the possible outcomes when a decision is ordered. Either it is rejected it is accepted or sent back to the trial chamber to reform it based on the errors that the judges may have determined in that decision. So it would have meant that those aspects that have been appealed could have been looked into or interpreted differently. Remember, they are four. They are not everything of the order. They did not represent the full order. It's just 14 out of them. They touched into several components, touching on harm, touching on the number of victims, the characterization of persons in camps, the breakdown of divisions, and when did it change? It did not change the conviction, and so they did not change the decision on the reparations. So the appeals chamber, its duty is to look into the law, whether there is an error in law, an error in procedure, or whether there's a misinterpretation of the applicable rules and procedures. And in all of this 14 grounds, the appeals chamber considered the trial chamber was consistent with the law. It did not make an error, or certain issues were already litigated before, and it was not necessary for the defense to open them up again at this stage.